Good evening, everyone, and welcome to another episode of the Wednesday webinar, Property Law Alliance. So good to have you all back with us. It's so good to have a full house as well. Hi, Greg. How are you?
Very well, Chris. How are you guys?
Very well. Cilna, how are you doing?
I'm very good, thank you, Chris. How are you?
I'm very well, very well. Bruno, how's things going on your end?
That was the shortest introduction we've ever had.
Because we've got a jam-packed session today, that's why.
Chris is focused tonight.
Right, fair enough. We need to get on a plane. We need to move. All right, got it.
No, it's really good to have a full, full house today with our experts. We've got a very interesting discussion that we're going to be having this evening. So we're going to be steering away from our normal program, which is to answer questions which have been posed in the group. But that's only because there's been a recent case and an article's been written about this case. And it revolves around a home in a very posh Joburg suburb. And that's the suburb of Dunkeld. And I read this article, it was published and it was about this case. And I must say, it stirred up quite a bit of fear in me as a property owner. So I'm going to go into the details quickly of this case for the viewers who have not, read the article or are not familiar with the case itself. But it revolves around a group of people who had hijacked a supposedly abandoned home, this being the home in Dunkeld. And the owner then proceeded to evict these occupants from the property. The court then deemed that this eviction was unlawful and basically came to the conclusion that these occupants would be able to, continue residing on the property. They could move back into the property, albeit for now, just for now. So that was the court case. Now, for me, this raises quite a number of concerns. So we'll post the article in the comment section so that everyone can have sight of that. But the concerns that it raises for me, first of all, is that these occupants were living in conditions that no person should have to endure. And I think it also revolves around the fact that I think a while back, there was a body that was found on this property. That raises safety and security concerns, not only for the occupants themselves, but for the neighborhood and the people around in this particular community. And then it also raises the concerns of this property owner, their rights to the use and enjoyment of their property. And obviously, there's going to be hefty costs associated with the failed eviction, of course, and then having to go back to court for, trying to progress with this in a legal manner to get the eviction done in a legal form. So my question, the first question I have is around how do we traverse the landscape between the rights of the haves and the have-nots, that being property owners and those who are most destitute within our communities? And then secondly, I want to find out that according to my knowledge, evictions can't happen right now. So, what was the story with this case? Because, clearly there was an eviction that occurred. So how did that happen? So I think what I'll do now is I'll just turn to Greg. Greg, you are very well versed in this field. So are Cilna and Bruno. Greg, can you please give me some insight into, how do you traverse this?
I think, with your permission, Chris, I'll leave the details of the matter to Bruno or Cilna, but you've asked an important question about the balancing of the rights, and I think this is really the constitutional imperative that sections 25 and 26 of the Constitution attempt to do, is the balance of rights between the property owner, which is entrenched, and the rights to have a place to live, which is equally entrenched, and the dichotomy between those two things. So this is the fight. This is the balance. This is what PI attempts to do, or let's rather say the constitutional litigation that spun out of PI over the last 20 years has tried to achieve. So in the normal course, it's fine. The owner has an occupier. The occupier stands to be evicted. And unless there's the danger of homelessness, which there seldom is, then an eviction order will be granted. But generally speaking, the court will make this inquiry. Now, all four of us have done evictions where out of Sandhurst or fancy suburbs where people raise the spectre of homelessness, which is clearly nonsense. So people will always have a go. And I think all of our experience is that the proving homelessness or the danger of homelessness is much harder than it seems. And obviously the case law over the years has made it more defined as to what would need to be shown to warrant a case of homelessness. Now, it's really not just there for the asking, but it doesn't mean that everybody doesn't ask it, if I can put it like that. So, the system is designed, and this is often why the frustration that our clients experience is based on the courts being very careful in particular about this inquiry, which is the key inquiry, in fact, in an eviction application. And some of our complaints and the complaints of our clients are related to the contortions the courts will sometimes go through to ensure that they are given sufficient information to answer that question fairly and properly.
Thanks for that information, Greg. I think, Cilna, you could just also give us an opinion on this particular matter as well.
Yes, so I think actually I want to start with discussion around eviction. And I actually think it's pretty cool that we're having the eviction in lockdown conversation tonight specifically. It's been a year, and to be honest, guys, I think we're sort of there where I can say happy anniversary. We started the Property Law Alliance last year, April, in the middle of lockdown, because there were stories and rumors that tenants didn't have to pay rent because we can't do evictions. I called Bruno and Greg desperately, and I said, guys, we need to do something. The poor industry is fed a load of nonsense, and luckily you guys are awesome friends and said, okay, luckily let's do it. And I think it's exactly for things like this article that creates a perception that landowners' rights are sort of at risk, or these fallacies out there that we can't do evictions right now. We've been evicting all the way since May last year, since level 4, without any issues. I mean, it's delayed, and we all know evictions are taking longer than usual, simply because the courts are slower and more congested, and you can't just quickly run and grab your file from the registrar if your matter is not properly enrolled. You have to smile politely and go out of the Teams meeting because a tantrum over virtual court doesn't help. It's just not as effective and as exciting.
And it's recorded.
And that's the other thing. And so evictions are taking a little longer. Instead of our typical 6 to 8 weeks, we are seeing evictions taking more in the region of 3 to 4 months. If it's unopposed, but it's working and it's happening. And it's been happening since May 2020. So I think that's the most important thing. The reason why this eviction took place was because evictions can be done. Fun fact, however, about this particular eviction, it wasn't an eviction. And the reason, I spoiled it. I was that person who spoiled Endgame for everybody, but I think it's a good spoiler, and now was a good time. But the reason why this eviction didn't work was because it wasn't an eviction. Section 26 of the Constitution says, no person may be evicted or have their property demolished without a court ordering to do so after the relevant circumstances has been taken into consideration. This is what Regulation 73 of the current lockdown regulations repeat verbatim. It is clause 26, section 26 of the Constitution. So we've never been able to, since promulgation of the Constitution, which was in 1997, since promulgation of the Constitution, we've never been able to do evictions without a court order. Even before that, you need a court order to get somebody evicted. It's like somebody can't just take your car back because you're not paying your installment. There has to be legal process and judicial oversight. This is how it works. It's the same way currently. And what happened in this particular matter is, unfortunately, the process the process to obtain an eviction order was never followed. There was no application for eviction. There was an interdict, and Bruno, I think you can go into a bit more detail there, but it was an interdict, interdicting more people from residing on the property. Doesn't deal with removing the people that were there. And Greg, I suppose we'll return again later to you with the involvement of the Red Ants, and we know that the Red Ants won't act without a court order. And I think it's an important conversation to have. So the newspaper articles and the headings that we are seeing about eviction denied, people can stay on the property, creates the impression that there was an eviction, it was unsuccessful. It was unsuccessful only on execution, and none of that is factually correct in law. In law, I wouldn't be able to get that eviction executed either. Why? Because there isn't an eviction order. And you can only execute an eviction order to remove people from land when you have a court order. And this is not just in terms of the lockdown regulations, this is in terms of the Constitution. So nothing new in our law. And if I bring an application or have a court order for something else, it's almost like having an order for payment of arrear rent and then being surprised that the court doesn't want to issue a warrant of ejectment to evict the non-paying tenants. If you don't have an order for eviction, you can't execute.
Sure. Thank you, Cilna. That actually, and I think that's where a lot of the fear came around. So when I read it, I was like, wow, exactly what you're saying. I mean, this was an eviction that all of a sudden goes wrong. And I mean, you spent tons of money to get this eviction underway. But it's, I think for me, it's peace of mind knowing that it actually was not an eviction. And perhaps this property owner, along with their attorneys, taken the law into their own hands, if we could put it that way, and acted outside of the scope of what they were allowed to do. So that brings me quite a lot of comfort in that regard. So thank you for that, Cilna. Bruno, I don't know if you want to touch quickly on that, what Cilna was saying around the interdict.
Well, look, so both Cilna and Greg have hit the nail on the head. And I think it goes down to the hype that's created by media articles that tend to bias one side over the other, or rather want to create headlines that attract readers. The problem that I have with this particular approach, especially when it comes to evictions, is when people read the article, they don't become acquainted with the truth throughout the reading of the article, because it starts becoming legally technical. So people don't understand what the eviction was, because one of the articles, if you read it properly, it does actually make sense. There was an eviction that took place. And I think that's also something maybe in law we should consider the wording that we use. So the eviction is the actual removing of people from the property, right? And then you could have something that's called a lawful eviction or unlawful eviction. So when you refer to the word eviction, it's this umbrella term of, getting people to move out. When I say I'm going to evict someone, I've had people fighting with me saying, you're not entitled to without a court order. So it's not a natural interpretation that when you say the word eviction, it's lawful. And I think the problem is when now the viewers or the readers see an article that says evictions are now being set aside, it starts creating confusion, because they might understand it as, oh, now lawful evictions are being set aside. So, I mean, at best, the article should say unlawful eviction being set aside or something along those lines, because that's really what happened. Is there was actual removal of people from the premises. There was no justifiable reason to do so. There wasn't a court order. You can only lawfully evict if there's a court order. No court order, you shouldn't be able to lawfully evict. You can unlawfully evict, but then it's spoliation. You can land up with the eviction being set aside. And I think the fear that an article like this causes without a proper explanation is why then we start getting phone calls from people saying, but now the courts have said that the regulations, because then they start quoting series saying, oh, series says that you're not allowed to execute evictions. And now they're connecting two things that have nothing to do with each other. That's not what the court ordered. The court didn't say you're not allowed to do evictions. It's a combination of factors. You're not allowed to do unlawful evictions. In fairness, you were never allowed to do unlawful evictions because you've always needed a court order. So this isn't new, but when somebody reads it, they associate now lockdown, no one can evict. You can evict. Nothing stops you from evicting during lockdown. The regulations make mention of how evictions are supposed to be approached. So there's certain considerations now that we need to bear in mind, but you can still do it. Lawfully, you can still do it. And again, this article doesn't really pinpoint that. It does create this perception that the courts have finally put their foot down and people should not be evicted, or no court order should be granted. That's not what happened here from my understanding. It was a wrongful execution of apparently an interdict. We don't have enough information to confirm that, but apparently there was an interdict preventing new occupants from occupying the property. It sounds like there was some attempt at executing and stopping these new occupiers from coming onto the property, but somehow this landed with the removal of old occupiers as well. But again, a logical reader would see this and go, oh, I get it now. I can't go and kick people out if I don't have a piece of paper that says kick them out. All the piece of paper said was don't let new people in. So it's intuitive. And I think once we get through that, it starts making sense to people.
Thanks, Bruno. I also just quickly, sorry, Greg, I know you're going to say something, but to keep in mind while you're going to answer is around the issue of Cilna raised around the red ants and how typically would one go about, engaging the services of red ants and then how would they operate once you've, followed the right procedure?
Yeah. Just to say that a court will not overturn a properly done eviction order. Can't even. I don't believe it can. So if there's any problem with the order, or if there's a problem with the execution, then the court's at liberty to reinstate people. A court will not and cannot reinstate people when a proper court order has been executed. There's no basis in law to do so. I think my colleagues agree with me on that point.
And if I may, Greg, I'm sorry, I want to just quickly latch on to that one. Sorry, Chris, I'm hijacking. But if we move to the execution, we're gonna miss this one. Exactly what you're saying, Greg, and I think, and I say this more to other attorneys, more colleagues watching than necessarily our viewers or other viewers. I think over the years that I've been training attorneys for LSSA on evictions, I've realized attorneys very often are scared of going for an eviction application. I mean, for us, it's the obvious thing and it's easy, and we can do an eviction basically with our eyes closed. Not really, because then you won't know everything should go. But we can do evictions in our sleep, and we will obviously opt for that first. But what I've seen is, unfortunately, if you're not really if you're not specializing in evictions, if you don't do it often, I have seen attorneys trying all sorts of other legal processes instead of going for the eviction because of the fear for going for the eviction, and I get it. But unfortunately, I've seen attorneys attempting to use an attachment order, a section 32 attachment, or a rent interdict summons, instead of going for eviction. Now, to the benefit of our viewers, you won't know the difference, because if you're not a trained attorney, you don't know what your notice of motion should look like. You don't know what the difference is between a notice of motion and a summons, because you're trusting your attorney for this. It's like you're not going to wake your surgeon in the, ask the surgeon to wake you in the middle of open heart surgery just so you can check if they're still on the right place. And the same with attorneys. You're trusting the attorney is doing the right thing. And very often, unfortunately, what the attorney might be busy with might not even be an eviction. It's a sort of other legal process, and it's all legal and it's all fair, but it's not the right thing. To get an eviction order, there's only one way, and it's to approach the court, either ideally on application, and ask for an eviction order. It can be done on summons as well, not ideal, it's going to take too long, but and ask the court papers must say, I want an order to have this person evicted and anybody else residing through and under him. If it's not that process, it's not an eviction. And when it fails, unfortunately, it hits the newspapers and social media in saying evictions are not being granted. And that was to your point, Bruno. That's why I just wanted to latch on to the term eviction. And I think it's important to know there's really only one legal process to get you to an eviction, and that's for asking the court for it. There's no other little shortcuts, wasting money with a rent interdict summons instead of a summons, right? Instead of an eviction application. Yes, it's handy stuff and we do use it, but your focus must be the eviction, and you won't get an eviction unless you ask for it. That's sort of how life works. Okay, now I'll keep quiet.
You certainly don't have to keep quiet. I think I completely agree with all of your comments. Eviction applications are administratively burdensome, and there's some funny time periods, and it's tricky. And unless you are, unless it's second nature to you, it is hard. I do, and I'm sure you guys do as well, quite a few evictions for colleagues, simply because they don't want to, learn the rather Byzantine mechanisms that one must employ to get an eviction order. There are two things that I must add. I would say, and I'm sure that you guys will agree, at least half of all one-off clients, as opposed to the sort of more experienced corporate clients who do evictions, will ask you, well, shouldn't I just get the red ants to go and evict them? The answer is no, and the answer is they won't. I mean, the red ants have been around for a long time, since about 95, not in that form. And they are very effective at what they do. They're also very cautious. They will not evict without a court order. They will not evict without the sheriff. They will make sure that there's police support. There are others that may dress in red overalls and kind of, try and steal some of the valor from the red ants. But normally you're not going to get any decent organization, and I include the red ants in that, to evict someone without a court order. So I'd be interested in seeing what actually happened here and who actually did it, because I'm pretty sure it wasn't the red ants. Let me also say that there are, you can evict without a court order, and you can evict using an interdict, but in very constrained circumstances. And Seri will disagree with me. In fact, I heard them talking on the news yesterday and saying things that I fundamentally disagree with. If you're in your lounge watching TV, some guy starts trying to put up a tent on your front lawn, you can physically stop that guy. You can throw him off your property. You can get your mates, get rid of him. Acting in hot pursuit remains part of our law. The second thing, and we're quite careful about this, we deal with a lot of land invasion matters and it's topical again, land invasions have kicked off again in the pre-election period, as they always do. But the way we punt it is, you can't evict someone from your home. At what stage does it become your home? I'm sure we've had this conversation before. Put up 4 poles and a roof, throw your sleeping bag on the ground. There are stun grenades going off. There's gas, someone's shooting rubber at you. Sorry, but that is not your home. That is now, don't come to court and say I've evicted you from your home without a court order. No chance in hell. That is not your home. Until there's some degree of permanence and an intention to reside, and we don't know exactly where that line comes in, but it's certainly no less than a few days. You can get an interdict and get rid of those people based on their spoliation of your property without jumping through the hoops of PI with the potential alternative accommodation demands, etc., etc. That would be ludicrous. And we've had a lot of success in this exact realm of saying to the court, the moment this guy is settled, we're into a 2-year process where these are potentially poor people, where the city might have to provide alternative accommodation. There are a lot of people trying to occupy this land, And if they set up, we are into an alternative accommodation story, and that may take a while. So there are circumstances. You are very unlikely. Well, no, that's not true. You get home tonight and someone is in your lounge, you know, with your slippers on, watching your TV. You don't need to
Not
wait
my
for
slippers.
not
Anything
your slip.
else, but not my slippers.
Okay, all right. Now that would lead to murder, mayhem, and insurrection. But it's you know, you can throw them out then and there, acting in hot pursuit. Go to the cops, get some. Let's not go into the detail of it, and I hope it doesn't happen. But it's you won't. That's not their home. Excuse me. So,
any question?
Pardon?
Can I do this? Can I do this with my in-laws? Because they often come to visit. Can I act in hot pursuit, Greg?
They move in tonight, I would bounce them with hot pursuit, especially if
I'm sorry to disturb you, but you were in a line of
no problem. Quite right too. But you know, it's not all about locking yourself into an eviction process. Invariably, tenant problems, etc., you are into an eviction process. There is nothing else. There is no other way. I think we have a high degree of consensus that all of these covert ops, sneaky tricks, none of them work at all. The only way is you start, you grind it out, and you get them gone. I must just brag a little bit. Just before my first reported case, just before before Pi came in, well, a client of mine had a bunch of informal settlers on their property and instructed me to evict them. And I started. They got bored. It didn't take long, but they got bored. Threw them off, burnt their stuff, ran into court in front of Judge Nugent, late of the SCA, and recently that tax inquiry. George Bezos of the Legal Resources Center on the other side, no less. And the old legislation, I think it was called the Illegal Eviction Act or something like that, allowed you to do it. And Judge Nugent was so cross that even though we were successful, he refused to give us costs. So because he couldn't grant a spoliation order, he couldn't reinstate them. And obviously that kind of legislation wasn't going to be long for the post-constitutional world.
That's crazy, Greg. Bruno, let's be fair. At the time that happened, and Pi was promulgated here, and I was still in high school.
Yeah,
I'm just saying, you definitely are a senior, Greg.
Kind words. I'm not 100% sure it might not have been primary school, but we'll
No, when was that? 1998.
Oh, okay. So close on things like that. I think. So look, there are circumstances, but you are not going to encounter those very often. Just a bit of background. You guys may recall, it must have been 5 or 6 years ago, the provincial government, which I think was the old provincial government in the Western Cape, used an interdict to get rid of a lot of those shacks next to the highway, and that caused a lot of problems for them. And it was condemned by the judiciary very roundly and properly, because people were using an interdict for a purpose it wasn't intended to be used for. So one has to be cautious. If you can't still smell the tear gas, you're not going to come right on an interdict.
Thank you so much, Greg. Thank you, Cilna. Thank you, Bruno, for this wealth of knowledge and for dispelling a lot of the fears that would come around when one reads an article like the one that was written, and to allay the fears that as property owners that we have on a daily basis. We're just not sure in terms of where the political landscape is going, but at least we know that our law stands by property owners alike, as well as those, like I said earlier, who are the most destitute within our communities. So thank you guys for this wealth of information. Thank you to the viewers for joining us this evening. I hope to see you all next week. Please remember to post your questions. And for those of you who have posted your questions, we will be addressing them next week. And yeah, please, we're looking forward to it. Join us, Bruno, Cilna, Greg. Thank you as always. Cheers, guys.
Thank you. Thanks,
Chris. Thanks, everyone.
Bye-bye.
Thanks, you guys.